What we wanted to do was to not move directly to a bill which we were taking through Parliament and its stages there. We wanted to show the whole community, and in particular the groups that have expressed an opinion on both sides of the debate on abortion, what it was that we were proposing to do, and still take into consideration any issues they may want to bring to our attention, any views they may want to express about the letter of the proposed legislation, because we're still in time, not just to legislate in a different way, but to publish a bill which is slightly different to what we are proposing. But the key thing is that what we propose will bring Gibraltar back into compliance with Article 8.1 of the European Convention of Human Rights and our own Section 7.1 of our Constitution. And that's a key fundamental issue for us, that we are now presently in the intolerable situation where we have been found to be in breach of Article 8 of the European Convention and Section 7 of the Gibraltar Constitution.
The command paper proposes certain changes to the law as it stands. So under these changes, under what circumstances would abortion be legal?
So there will be 5 circumstances when abortion is envisaged to be allowed. The first is already provided for in our law, and that's whether there is a serious risk to the life of the mother. The next 2 also relate to the mother. They are situations where the mother's physical health is at risk or where her mental health is at risk. Those things will have to be determined and certified only by GHA doctors. We won't allow commercial certification of that risk. The next 2 elements relate to the state of the fetus, the state of health of the fetus. So the first relates to a fatal fetal abnormality, and the 5th relates to a serious disability if the fetus were born as a child. Now, in relation to the latter, that is already the situation because the GHA has been testing for 30 odd years, and if the tests are then taken outside of Gibraltar because you need more detail, if it doesn't look good, then the option to terminate is being offered already outside of Gibraltar, where we have sent people for the further testing. In relation to the option which relates to the mother's mental health, the reason we have included that is because the Supreme Court decision in the UK says that there must be abortion available in cases of rape or incest and in cases of fatal fetal abnormality. We've dealt with fatal fetal abnormality a moment ago. In relation to the mental health of the mother, we will see those who manifest with an allegation of conception through rape or through an incestuous relationship. We couldn't design, in the way that was viable, a law that provides for rape in cases of alleged rape, provides for abortion in cases of alleged rape or incest, because the allegation would be made, the window for the abortion to be carried out in those circumstances is a short one. The window we're proposing is 10 to 14 weeks, not the 24-week provision in the UK law. But then the finding about whether the person against whom rape is alleged, whether that has actually happened, that would come 24, 36 months later. So you might find a woman has made an allegation of rape, has had an abortion on the grounds of that allegation, and then the alleged rapist is acquitted by the Supreme Court. What happens then in the logic of why the woman was offered the abortion? So the only way that we've been able to ensure that we comply with the Supreme Court's obligation on us now to ensure that there is rape and incest cases with an offer of a termination or the ability for a termination is to have that mental aspect which relates to the woman provided for.
The command paper goes beyond the law, so to speak, and makes certain recommendations on sexual health and education. Can you go into these?
We need to provide the backup there so that people are able to go through the period of gestation and know that if they have the child, they will be able to cope because we'll provide the support. They will be able to afford the child because we'll provide the support. Or indeed, if they are persuaded to go through the period of gestation because they don't want to go through an abortion, because they should also have advice on abortion and what it means, and that there should be no shame associated with those choices. We need to move away from stigmatizing contraception and terminations in these very limited contexts, that in those situations we should also be educating people and we should be providing facilities for adoption and foster care in a way that is very agile. And also educating people in schools, in modern, fit-for-purpose sexual education. Yesterday the GHA put out a statement on the Well Person Clinic it's setting up, which will deal with a lot of these issues. But this is not just for the health services, also for the social services to ensure they provide.
When do you expect the bill to go to Parliament?
So we are offering people 4 weeks as the period to consider the command paper and to respond to us. We hope that they'll provide early in that period, so we have time to consider the responses. I expect that we will publish a bill a week or two after that, depending on the responses that we get. So it may be that we are able to bring this law into effect this calendar year, with such changes as we may be persuaded to make to it after the period of publication of the command paper and the debate in Parliament, or the period of publication of the bill. But we may not be able to wait the full 6 weeks, because knowing we are in breach of our constitutional obligations, that is intolerable, and we must do that as a matter of urgency, therefore.